my firm has represented tenant groups. Maybe about 30 years ago, I was in the lobby of a building in which there was a tenant association being formed. The building had just received the red herring, the proposed offering plan to convert. Prices were astronomical. Most of the people in the lobby were rent-controlled tenants, had been there for a very, very long period of time. And I was there giving my spiel about what co-op is all about and how this may be an opportunity if the price is right that you might want to buy, et cetera, et cetera. During the course of the evening, an elderly woman raised her hand, called on her, of course. She said, "Mr. McConnell, there's an old Russian proverb that when you own property, you are happy for 2 days. The day you buy it and the day you sell it." But what I'd like to do is talk a little bit about what happens in between. As Bruce pointed out, and some of the issues that arise and what remedies and rights unit owners and cooperators have in connection with those issues that might arise. Repairs. Who's responsible for repairs? There's something happening in the building. You're a cooperator. You want to get it fixed. There's no heat. Plumbing doesn't work right in your line. What do you do? And similarly with regard to a condominium unit owner. Well, as Bruce pointed out, the relationship in a cooperative is that a person has a lease and, in effect, is a renter of that unit. Owns shares of stock in the corporation that owns the building, but is a renter. And that lease is a binding legal document, of course. And in New York, each lease has written into it what's called an implied warranty of habitability. Your rent-stabilized tenant, your free market tenant, rent-controlled tenant, or a proprietary lessee, which is what we call tenant shareholders. You have the right to a habitable apartment. If that right is breached by the co-op and your apartment is uninhabitable, you have the right to withhold your maintenance, in effect go on a rent strike. You have the right to bring what's called an HP action, which is an action which is commenced in housing court in which the tenant, cooperator, goes into court saying, "Judge, there's a problem in my building. These constitute violations. I want you to order the owner, the co-op, to fix these problems." Of course, in effect, what you're doing is suing yourself, but oftentimes that's the only way to get work done. In a condominium association situation, it's different. As Bruce also pointed out, it's not a landlord-tenant relationship. The unit owner owns that little box in the sky, and they're an owner of that apartment. So they cannot withhold common charges. There's no connection between the warranty of habitability as there is in a lease situation in a condominium unit owner situation. But nonetheless, that condominium unit owner has the right to a habitable apartment under the terms of the condominium declaration and the condominium bylaws, both of which are documents which are part of the offering plan that's filed at the Attorney General's office, also on record in the county registrar's office. So you're not getting the services that the condominium documents say you're entitled to. What do you do? Well, you can't withhold common charges. You can, however, bring this action called an HP action, which again is going to housing court, in which you sue the condominium. And it's still a little bit unsettled in New York, but it's fairly well settled in this department in Manhattan that you can commence that sort of an action in housing court to get a judge to order, a housing court judge. The nature of this HP action is designed to be user-friendly. It's supposed to be geared towards consumers and to have them do it on a pro se basis. The other alternative, of course, is to go into New York State Supreme Court, bringing injunctive relief, saying that the condominium association, the condominium board, has violated these provisions of the condominium documents, and therefore you're entitled to injunctive relief against the condominium to get them to do these repairs. That's the repairs issue. Other thing that we often see is books and records of the co-op in the condominium. Okay, I'm a cooperator. I've lived there for 4 or 5 years. I get the financial statements every year, but something just doesn't seem right. What can I do? I want to see what the books and records of the corporation indicate as to what's happening with the money. And there's some very good case law in New York saying that a shareholder of a corporation, which that tenant cooperator is, has the right to look at the books and records of the corporation. the financial books and records, a right to see who the other unit owners are in the building and their addresses as well. In a condominium situation, there is some case law on that issue, giving the condominium unit owner that sort of right, but there's also usually a provision in the condominium documents, the bylaws, the condominium declaration, which gives that unit owner the right. There are many co-ops out there, many condominium associations, which will willingly allow their tenant shareholders, their unit owners, to look at the books and records. Unfortunately, there are some that don't. The only alternative for that unit owner, be it a tenant shareholder or be it a condominium unit owner, if their letters and their requests of the condominium or the co-op are unanswered, or the answer is no, is to bring some sort of litigation in New York State Supreme Court, looking for a judge to direct the condominium or the co-op to allow this shareholder, who's a part of the co-op, or this condominium unit owner who is part of the condominium, the right to look at those books and records. Right to sell and lease, different issues with regard to the co-op owner or with regard to a condominium unit owner. I'm a co-operator, I want to sell my apartment. What can I do? I want to lease my apartment. That is, the selling and leasing of apartments is determined by what the proprietary lease says, and most proprietary leases say that you need the consent of the board of directors of the corporation to sell or to lease, and that consent can be withheld for no reason or for any reason. Now, there's been all bills in the, I believe, City Council pending with regard to whether co-ops have to disclose what the reason is to the shareholder if they are denied. I don't know how far those bills are going to go, but they're out there. With regard to a condominium unit owner, selling and leasing, a little bit different. The condominium unit owner generally has to go to the board, and the board has the right of first refusal, what they call. So if you wanted to sell your condominium unit to me, and you have a contract with me, and I'm going to buy it for 1.2, the condominium board has to look at it, and if the board really doesn't want me there, for all kinds of reasons, wise guy lawyer, the remedy is to buy it from you for that 1.2 million. They can't say no. What they can do is that right of first refusal. They buy it from the unit owner. You make your money. You move on. The condominium does with whatever it wants to do with it, but it keeps out Kevin McConnell from that building and all those issues that I've come with. New construction problems, a phenomenon that we are seeing throughout the city. Buildings are built, and they have problems from the day that the first closing takes place. One has the right, of course, to complain to the Attorney General's office. I don't know whether Mercer is going to touch on this topic, and the Attorney General's office has some very nice enforcement powers, depending upon what's said in the condominium or the co-op documents. What does the offering plan say? What did the sponsor agree to give you as part of your purchase into this condominium? What were you told that you would acquire? What was the building going to consist of? What was going to happen with regard to the insulation of the building? What was the heating element supposed to be? Those documents, that document, the offering plan, not only gives the Attorney General enforcement powers, but also there is a basis on which you can claim a contractual right. I signed an agreement to buy. I signed an agreement to buy in this building. This offering plan was incorporated into this contract. I have rights pursuant to that. This is a real developing situation in the law. Courts haven't really come down as to what the rights are of the unit owner, the purchaser in that situation, and it's really murky. But let's hope. One possibility could be is that the state legislature could pass what they call a private cause of action under the co-op and condominium laws, in which individuals have the right to sue under the law rather than by contract for what wasn't delivered to them at the time that they purchased. Other thing that I see is folks sometimes, so you've done the closing, you're done, you got your deed, you got your stock certificate, you got your mortgage, and you walk out and you say, what did I buy? What did I just buy? Some litigation that we've had involves roof rights. People say, I thought I bought roof rights here. Well, let's look at the documents. What does the condominium plan say with regard to whether your unit has roof rights or not? If you bought a co-op, what does the co-op document say? What does the proprietary lease say as to whether that piece of the roof is really yours or not? It's too late after you've gotten your deed and you've given your money and you entered into your mortgage to try to figure out what you bought. It's extremely important then that if you're thinking about buying a co-op or condominium and you think it includes the backyard, you tell your lawyer, you know, there's this backyard. My apartment empties out into this backyard. I'm the only one who has access. I want to make sure, though, that it's really mine. And in a condominium situation, unlike a co-op situation, there are what they call maps, which are floor plans, which lay out, this belongs to this unit, this belongs to that unit. They're wonderful documents, easily accessible, 66 John Street, 13th floor. So if you think about buying something and you think it includes something other than the four walls of your unit, make sure your lawyer checks it out and make sure that you check it out because it's easily accessible to the public.